Good morning, everyone. My name is Maria Mejia-Opaciuch, and I'm a Senior Counsel at Carlton Jordan Burt, PA, located in Miami, Florida. And we're going to be discussing the U.S. immigration policy and procedural changes that are impacting foreign students. We will discuss travel, work, study, and stays in the United States under these new policy and procedural changes. We're going to cover 5 different topics under this presentation, and we will be doing certain topics in sessions 1, 2, and 3. The sessions will cover the primary topics that you see here on this page, and also I want to let you all know that at the back of each of the presentations we have composed a list of resources that you will find helpful in order to maintain your ability to stay in the United States, and also topics that may impact your stay in the United States, your studies in the United States. The resources are very well organized by the USCIS or the various government agencies that govern immigrating to the United States and studying in the United States. And after the list of resources, we have also included a glossary of all of the terms that we use throughout the presentation. It'll have sort of a minimal definition of the terms that we're using here, as well as to spell out the acronyms that you'll hear throughout the presentation. Okay, wanted just to let you know that for administrative purposes, so that way when you go through these presentations you're aware of those 2 items. So we're going to start here to go over the topics that I'll discuss in this presentation. We're going to have session 1, which will cover a very important policy memo that was issued by the U.S. Immigration Services in August of 2018. And I'll discuss how it affects your travel and, very importantly, the accrual of unlawful presence by students if you're not careful of maintaining your records while you're in the U.S. and traveling to the U.S. That'll be session 1. Sessions 2 and 3 will make up the bulk of the second presentation, and in there we will discuss foreign travel after graduation and under optional practical training, the OPT endorsement, as well as discussing some of the delays and procedural changes in petition processing at the USCIS offices in the United States, and those delays thereafter at the U.S. consulates when you appear for the visa stamping. These delays will affect some of your start dates and returning to the U.S. after short travel or any vacation or holiday travel. Then the last session will cover employment as a tenured professional in academia, and we'll discuss employment as a professional staff member in academia. Though that will comprise the last session, and we'll go over some of the issues that both the employer will be looking at, as well as you, the student, as a potential employee. Okay, so we're going to tackle the first session here, where we discuss this August 2018 U.S. Citizenship and Immigration Services, known as USCIS, when they issued an unlawful presence memorandum, and we'll discuss the effect on travel and accrual of unlawful presence by students. As you may all know, in August of 2018, just a few short months ago, the USCIS issued the Unlawful Presence Memo. And what that does is it affects the individuals that are in the U.S. or outside the U.S. who are attempting to re-enter the U.S. It'll affect students on the F1 visa and the M1 vocational visas, as well as the F2 and M2 dependents. So family members are included in this policy memorandum, and all should be aware of every family member's travel in and out of the United States, as well as their stay in the United States. The policy memo also impacts trainees on J-1 visas, as well as their dependents, the J-2s. The effective date was August 9, 2018, and the USCIS policy memorandum number is right here. You'll see PM standing for policy memorandum, and that number may not really mean much to you, but you may see it included in certain documents that you may receive from either the USCIS or your student advisors, international student advisors. So I point that policy memorandum out to you so you have that. It also, the governing statute, the law of the land in the immigration arena is the Immigration and Nationality Act, INA, Section 212, and the pertinent ones here that are going to be relevant would be sections A, 9, B, and C. Those are the sections that discuss students in the United States and the discussion of unlawful presence in the United States and how it would impact your ability to return to the United States if you accrue a certain number of days. And so that section is important for all to just be aware of the discussion on unlawful presence. So what does this policy memo mean, and why is it important? It's a memo that is going to be incredibly relevant for individuals that travel in and out of the U.S. And are studying in the U.S. and may change programs in the U.S. or be reinstated for not being in the U.S. for the amount of days necessary on your F, M, or J visa. It's a memorandum that now very clearly states how the USCIS is calculating unlawful presence. And it will also revise the USCIS's Adjudicators Field Manual, the AFM. And that manual is key for the U.S. Department of State consular officers that will be reviewing past stays in the United States under the F, M, or J visa. And it is also the manual that is used by the USCIS officers in the United States at the service centers when reviewing any requests for change of status or extension of status, or actually even requesting a new status if you're going to be going from an F, M, or J visa to a work visa, possibly an H-1B, or even if you are a student in the United States seeking to extend OPT and in the U.S. Under having studied under a STEM discipline, and you're seeking to extend your OPT for the additional 24 months, the AFM will be looked at by the USCIS officers and adjudicators when they are going to make decisions on any of these applications that I just mentioned. So, and why is this memo so new to all of us and so very important for us to be aware of? It's because the old policy memo, one that dates back to 1997, and it was issued by Paul Virtue, who was an officer within the USCIS adjudication offices. It's known as the Virtue Memo. And in that memo, it was stated that there would be no unlawful presence accrual for F, M, and J overstays or violators if they just remained in the United States. And there was no finding by either an immigration judge or an USCIS adjudicator's decision. So they would not be exposed, you students would not be exposed to a 3-year or 10-year bar unless there was that finding. So unlawful presence clock actually started on the date of the decision, again, either by the immigration judge or a decision from the USCIS. So unless there were those two events, FM or Js could be in the U.S. under duration of status, DS, and not accrue any unlawful presence if there were changes in the program or they overstayed their visa in the U.S. So this is a very critical memo now, in that as of August 9, 2018, the new policy went into effect. And unlawful presence begins on the day after an individual either overstays their program, their study program, or training program, or there's a violation without a formal finding, meaning if you were to work without OPT, that would be a violation that would accrue, expose the student to a risk of exposure to the 3-year and 10-year bars. The 3-year bar are for those that overstay or violate for 181 days up to a year, and the 10-year bar is for folks that stay 1 year or more, overstay or violate for 1 year or more. Therefore, it is really important from August of 2018 and going forward to take a look at what it is you want to do in the United States and remain compliant in the United States under any one of these 3 visas, the F, M, or J visa. Calculation methods. How will the USCIS calculate overstays or violations or offenses? So prior to August 9, 2018, if there is a student here in the United States who's accrued any unlawful presence by either working without authorization, overstaying their status, and the offense took place before August 9, 2018, the accrual of unlawful presence begins on August 9, 2018. Or unless there was, of course, either a USCIS decision or an immigration judge's decision with an expired I-94 date certain, then the earlier of the 2 dates, the one of August 9, or if there was a decision, that will control. So it is very important to review old stays in the United States on an F, M, or J visa to take a look if there was any violation or an overstay, and ensure that if there was and you're in the United States on August 9 or later, that you are aware of the accrual beginning on August 9 and not stay here in the United States past 180 days, which would be sometime February 5, 2019. Otherwise, you will trigger the 3-year bar. Or if you're going to stay a whole year through August 19, 2019, then you're triggering the 10-year bar. Very important to take a look at old stays in the United States and ensure you understand the obligation to depart the United States timely, or at a minimum seek solid, sound immigration advice from an immigration attorney. As of August 9, 2018, with this new policy memo, you begin to accrue unlawful presence on the earliest of the days after any one of the 4 events listed here. That is, if you're no longer in the U.S. pursuing an F, M, or J program, or you're engaged in unauthorized activities such as work without authorization. If you've done it from August 9, 2018 forward, be aware that you're now beginning to accrue unlawful presence and calculate dates carefully so you do not trigger the 3-year or 10-year bar. The same is true if you've completed your F, M, or J program, including the optional practical training and the grace period, which is 30 days for Js or 60 days, for F visas, that you are aware of those dates. Or if you have an I-94 that had an exact expiration date, a date certain, instead of the typical DS endorsement, then you start to accrue. Or if there's been an immigration judge's order to depart the United States, or a Board of Immigration Appeals order, a BIA order, then you want to make sure you're calculating the days carefully so that you're not accruing any unlawful presence of triggering the 3-year or 10-year bar. So many of you are asking, how will the USCIS know of an overstay or the violation? The first place that the USCIS officers will visit and actually monitor continuously are the SEVIS records that are found in the Student and Exchange Visitor Program system. Those records are going to be monitored very carefully by the USCIS under this new policy memorandum. As we all know, this administration is interested in maintaining order in the United States and monitoring individuals who are coming to the U.S. under any temporary visa, including J, F, or M visas. The other record that they will be monitoring is the actual foreign nationals record, which is the I-94 record when they're admitted at inspections or in any application that is submitted to the USCIS, such as an extension of status or a change of status or a work visa petition. Any such benefit application, they're going to be looking at those records very carefully, and the officers or adjudicators at the service centers reviewing any such applications are going to check the record carefully and go back to any possible violations that have occurred, such as an overstay or work without authorization. They're going to be looking, again, as part of some of the applications that are submitted to the Immigration Service for work visas or change of status or extensions. The USCIS may request further evidence or further information, and they'll issue a request for further evidence, an RFE, where they may be asking for certain information regarding prior stays in the United States or extensions. And this record, this RFE, is again part of the record that the USCIS will be reviewing. Furthermore, the DHS, as part of executive orders early in January of 2017, where the administration requested that all agencies governing immigration maintain reports and statistics of all sorts of different information, including this one that was compiled in 2016, which had an entry and exit overstay report. The DHS will be issuing such reports regularly in either 1 or 2 year increments, whereby they have easy access to information of individuals who have overstayed their stay in the United States. So we would like to give you some tips on how to protect yourself and prepare for this new policy that is now in effect roughly 3 months, and how it impacts your status, the visa stamping, and travel. So you want to always ensure that your SEVIS record is correct and complete. You have access to such a record, and you can work hand in hand with the designated school officer or international student advisor at the university or college's international student offices, where you want to make sure that the records are clean, correct, and that there's no misinformation entered accidentally or just probably some sloppy record keeping by those offices. You want to make sure that those records are correct, and so you should, as a practical practice, you should be asking the DSO and ISA for copies of your SEVIS records anytime you're going to depart the United States internationally, and when you return into the United States, again checking your I-94 record and your SEVIS record so that everything is entered correctly and cleanly. There is, unfortunately, as a part of this new policy, the USCIS and the enforcement arm, the Immigration Customs Enforcement Agency, ICE, they are not obligated to provide any notice to any individual under those visa classifications about the records, and so it is going to be a very very important, essential, that this becomes your burden, your responsibility, not burden, but responsibility to maintain records. Make sure that you note your graduation date. Make sure you note the date you apply for employment authorization document. Comply with all of those dates that are critical in your maintaining status in the United States. The DSO and the international student advisors also can give you a record of those particular critical dates of when you have to maintain your course load, your graduation date, your application process, whether it's for CPT or OPT, or even OPT extensions under the STEM program. Really important to keep those dates neatly and carefully. Use your smartphones to have reminders for yourself so that you don't pass any dates that are going to be critical, impacting your ability to in the future remain here or travel back into the United States or get visa stamps overseas. Also, you want to make sure you go back in time for any possible violations or overstays. Review your travel and study program. Go back in time. Make sure there were no gaps that were in those dates when you were in the United States. It's important to note those possible overstays or violations and discuss with your ISO or your DSO or your immigration attorney how you can annotate and keep an explanation for any possible overstays, because this new policy will impact those prior overstays as well. And additionally, you must do this as well for your dependent family members, because they may not be aware of all the intricacies of the dates coming and going in and out of the United States, and you do not want to expose them to any possible accrual of unlawful presence that in the long run will hurt them in the future should they be seeking an immigration benefit. Now we get to the slide with our questions and answers. And while I only have 6 questions on this particular slide, and I'll answer them in a minute, I do want to point out that if there's a question at this point of the presentation, please feel free to email me or call me with the questions you may have. My information, contact information, is at the end of the presentation. So I'm going to take one by one and go through them. So why was this new policy issued? And really it's in keeping with this administration's intentions to make sure that the immigration services and the agencies that govern immigration and monitor immigration into the U.S. are keeping a tab, if you will, of individuals who have overstayed their status, and they want to ensure the integrity of the system is maintained. And so the open-ended ability for foreign students or J1s and Ms in the United States to stay for duration of status time and overstay their visas was one of the main goals of controlling some of the foreign nationals in those classifications. So this policy is really in keeping with actually the executive orders that the administration issued early on in January of 2017. Now we have a variety of policy memorandums that are being issued, not just in the student context, but as well as in other legal immigration policies and programs that the administration wants to tighten and make sure that there is a control of individuals coming in and out of the United States. Number 2, who is enforcing this new policy? So the most obvious agency, of course, is the U.S. Citizenship and Immigration Services, the agency that's actually responsible for processing applications for immigration benefits. They're the ones that are going to be looking at any change of status applications or extensions of certain applications, and even reinstatement applications for students. They're going to be sort of the front end and the front line looking at the applications and enforcing and making sure this policy is being adhered to. But the other agencies that you need to be aware of course, are the U.S. Customs and Border Protection, the BP. That's the agency responsible at the airports and ports of entry in the United States that will be reviewing an individual's records when they are coming into the United States or re-entering from being overseas, and ensuring that the record of overstays is clean. And they may actually have shared information from other agencies that may bring to light that someone has overstayed in the past, and may in fact deny entry if there's an overstay of more than 180 days or a year, putting into place the 3 and 10-year bars that we spoke about earlier. The other agency, of course, is ICE, Immigration and Customs Enforcement, the agency that is responsible for maintaining and reviewing the SEVIS records that, of course, have all the dates of students, Fs, Ms, or Js, and their status in the United States. So they're also going to be reviewing the SEVIS record regularly, and will ensure that there is information sent to either ISA or DSO officers regarding possibly individuals that have a gap in their status. So you want to make sure that you keep those records clean, as we said, of course, a number of times throughout the presentation. The other agency, while not in the United States, is the U.S. Department of State through the U.S. consulates overseas that will also be enforcing this policy, and will be reviewing any kind of visa applications, whether it's a tourist visa, another F visa, possibly a J visa, or a work visa, an H-1B visa or an L-1 visa. If an individual qualifies, the Department of State, through these consular officers, the non-immigrant visa unit, NIV unit, will be reviewing records to ensure that there has been no gap in stays in the United States, overstays in the United States, that would then render the visa application null and void and not have the visa issued to the individual. So a number of government agencies, and then of course the private sector through the international student officers and the designated school officials, DSOs. They too will also be enforcing it, reviewing the SEVIS records, and maybe advising students to seek advice from immigration attorneys if they see that there's been any gap in time in the past that could jeopardize any future immigration applications or benefits that someone is seeking. So the private sector indirectly will be, of course, enforcing this policy. Number 3, how are schools or universities implementing this new policy? Okay, so universities now, with the complexity of this policy memorandum and the negative and severe impact that any prior overstays or prior violations of a stay in the United States could have on a foreign student's ability to travel and return to the United States, has rendered these schools almost put them in a place where they no longer are confident in their ability to give advice that would protect the student's body. They are now advising students to seek the advice of immigration attorneys so that any possible gaps in prior stays or possibly having worked without any authorization is explained to the students, and then of course immigration attorneys would be in a position to advise as to whether it's wise to depart the United States and attempt re-entry to the United States. So you want to make sure that you have a close relationship with your DSO or your ISA office, and look at your prior records so that you know if you've had any gap that could render you unable to return to the U.S. and maybe be subjected to the 3-year or 10-year bar. So you want to make sure that you're speaking to those officers. If you feel that it's best to get legal advice, then seek that legal advice before any travel is ensued and you depart the United States. Number 4, can you give examples of how this new policy could impact a student seeking an H-1B visa? Okay, as we've spoken a number of times throughout this presentation, the fact that there may have been a gap in stay in your study program, or a changeover to a different school where there was a gap in time where you attended school, or you may have undertaken some work without any authorization, then you want to make sure that that is not going to impact your ability to get an H-1B visa stamp. And even before you apply for an H-1B visa stamp, assuming there's an approval, when you apply for an H-1B visa through a change of status procedure, you want to make sure that if you're using the services of an immigration attorney, your record is fully reviewed and explored from the time you entered initially on your F1 student visa or a J or an M, and any time in the U.S. and possibly if there was some work. You want to make sure that everyone is aware of such events so that it's fully explained and it's not going to negatively impact your H-1B. Number 5, can you give examples of how this new policy could impact a student seeking a green card? And again, herein you want to make sure any prior stays on an F, J, or M visa and any prior gaps or changeovers in programs are correctly detailed, and if you've worked without authorization, once again, you want to make sure that all of those events are fully detailed in your application if necessary. And again, this may be the time when you would be speaking to an immigration attorney and being assisted in the whole process. So you want to make sure your immigration attorney is fully aware of any of those particular gaps. Get all of your I-20 AD forms in order. Look at the U.S. Customs and Border Protection website, I-94 retrieval system. Get the listing of travel, the travel history printed out so that it's clear that hopefully there is no gap in any time, and you have the recorded periods of time in and out of the United States from the official government website, and you can use that in your applications if necessary. Number 6, can you give examples of how this new policy could impact a student who travels after the effective date of the policy? Again, before you travel, you want to ensure that you reviewed. Before you travel internationally, you want to ensure that you have all of your stays in the United States completely mapped out and handy in the event when you return to the United States you are questioned about prior stays in the U.S. You want to make sure your I-20 ADs are all in order, and you should be carrying these documents, the travel history, the I-20 ADs, a chart of your travels if there's differences between your chart and the Customs and Border Protection I-94 records. You want to have all of that in hand so that if there's any questioning of prior overstays by the U.S. Customs and Border at the time of entry, you're able to detail them clearly and correctly. Sometimes the government records are not always correct, and you want to have that in your hand and ready to be able to explain to a Customs and Border Protection officer should you be placed in what we call secondary inspection. That is, after your initial inspection at the airport or at port of entry, you're asked to see someone in the back room or the supervisor and have secondary inspection conducted. You want to be ready for that particular process. Again, that's the questions I have now, but of course if there are more questions, feel free to, of course, email me or call me. My contact information is at the end of this presentation. The resources that I mentioned earlier on when we discussed at the opening, the resources that I provide for all of you. I have provided for you mainly the U.S. government agencies' websites, as those are, I believe, the most accurate, most up-to-date, most informative on the new policy memos that may be issued or discussion of the one that just went into effect in August. Those sites are very helpful to maintain up-to-date and current on changes. There's also the NAFSA, which is the National Association of Foreign Students Association, that will be very helpful as well. That website also discusses any policies, procedural changes that are going to impact students as they travel. And lastly, do take advantage of your international student advisors or officers. Those offices also are going to be very useful to you when you have any specific questions pertaining to your specific situation, and more generally if there's any policy that may be coming into effect or that is in effect that could impact your ability to stay and work in the U.S. This glossary here is going to again be included in all of our presentations, and it has a listing of the acronyms that I have used throughout the presentation and which you may encounter when you're reading any information on the website. So this again, do refer to it. It's helpful for understanding the what we call the alphabet soup of immigration, but it is a lot of acronyms, so it is helpful to have this handy. Okay, this concludes our presentation, the first session of the webinar. Again, feel free to reach out to me. Thank you.